We will call this next case in re Guardianship of Orta minor. This is the 15-minute mini oral argument on the application. Mr. Permet, you will be able to reserve some of that time, although we ask you to try to manage that and it doesn't always work out. We wish you the best of luck with that. And you may proceed when you are ready.
Thank you, Your Honor. Good morning. May it please the court, may it please opposing counsel. This case is somewhat interesting appeal coming from the Court of Appeals that dealt with guardianships, specifically private guardianships. Now, what the Court of Appeals here did was use a case called Ferranti to essentially allow someone to appeal an initial guardianship order years after that guardianship was entered. Now, Ferranti was never designed to apply to guardianships. It was designed initially as a way to allow parents to appeal an early child protection order later on in the child protection case, all the way through the child protection case. It was never anticipated that it would ever apply in guardianship. However, the Court of Appeals did use that case to allow the mother here, Ms. Orta, to appeal a much earlier guardianship order. So that was something that was never anticipated by the court, but it was used here. The second issue before us is this issue of residency. What does residency mean when we're talking about a 2B guardianship? Traditionally, guardianships, specifically 2B guardianships and all private guardianships under EPIC, were designed to be impermanent. They were designed to be temporary. There was never an idea that a guardianship would last forever, a private guardianship would last forever. But what the Court of Appeals here did was say there is a permanency requirement here. So the trial court would have to find, before ordering a 2B guardianship, that the parent intended for this child to remain with the third-party guardian essentially forever. That is not what the legislature ever intended when they created these 2B guardianships. It's a rule that's been in place for a long time and has never had a permanency element implied into it. However, that's what the Court of Appeals did here. And what the Court of Appeals did was leave guardianship law in a state of confusion. Now, on the ground, I think the courts and the practitioners are confused about what guardianships are able to do, specifically what 2B guardianships are able to do. Because, again, traditionally, we have these guardianships that can be ordered based on a parent leaving a child for some period of time without proper support with this third party. Now, those children were protected by 2B guardianships, but now we need to find, instead of leaving the child for some period of time, that the child was left there permanently. And that's a much different classification than previously existed. So I think the courts need some guidance here.
Let me interrupt you, Mr. Permet, and see what questions the court has for you. Thank you. Justice Viviano.
One of my concerns about what the Court of Appeals did here in allowing the initial guardianship decision to be contested on appeal at any time, even years down the road. And I know you said these are usually temporary, but sometimes, like in this case, they last a period of years, is that it conflicts with the legislature's intent, because it specifically provides in other statutes and gives parents the opportunity to petition the court to terminate a guardianship. But then it requires the court to take into consideration the best interest of the minor in making that determination. And so I'm concerned that the Court of Appeals decision upends the statutory scheme. Do you have any thoughts on that?
I do, Your Honor. I appreciate the question. I think the court is right to point out that the Court of Appeals opinion actually goes out of its way, I think, not to discuss the best interests of the child here. What it did was kind of skirt around the collateral bar rule by using Ferranti, which again is not something that was ever designed to apply to guardianship, and allowed this mother to appeal something that was years and years old and should never have been allowed to appeal in the first place. I think the implication of the question is why should we allow appeals this late in the game? And the answer in child protection context, where Ferranti was designed to apply, is I think mostly out of practicality. When we're in a child protection context, we have this child who's been removed from their parents' home. We have an adjudication hearing somewhere down the line, and then we have to decide whether there's going to be a dispositional order to allow a case plan to allow the child to return to their parents' care. So at every one of those dispositional hearings, we can't retry the entire case. So it's a matter of practicality to treat all these cases as one continuous hearing, and then at any time someone can appeal. In guardianship cases, especially private guardianship cases, it's simply not like that. There's much more of an analysis of what's going on at the time of the next hearing than you would ordinarily see at a dispositional hearing. And that's why I think there should be some kind of a cutoff where someone has to appeal by right within a certain period of time where they lose that right.
Also the notion that in the termination of parental rights, that's a final determination by the court. And these guardianship determinations are never final and are always subject to challenge by the parent, right?
I completely agree, Your Honor.
Okay, thank you, counsel.
Thank you.
Justice Bernstein?
Yes, counsel, I guess my question would be when we get into the question or discussion about reside, I mean, ultimately in this case, what should the, obviously this is a person in distress, what should the parents have done in this situation that would be different?
I don't think they really should have done anything different, Your Honor. I think the mother did the right thing. What she felt was that, hey, for a while here, I can't care for my child, and I know I have my mother who's a good caretaker for these children. So she went to the mother and said, can you care for my children? Now, initially, we didn't know how long this was going to last. I think there was some implication in Ms. Orta's brief that this was just for summer vacation, but I don't think that's quite accurate. This was to allow the grandmother to care for the child for some indeterminate period of time. She did, I think, take some steps. She wrote down what I think was effectively a power of attorney, or what she intended to be a power of attorney, to allow the grandmother to care for this child for a while. But when 1 month turned into 2, turned into 6, at some point the grandmother needed something more than a power of attorney. I think in Trudeau v. Martin, this court found that a power of attorney is not good enough in the long term. It might be okay in the short term, but it's not good enough in the long term. And at some point, these children were going to need to go to the doctor. They were going to need to go to school. And the grandmother was going to have to exercise those legal custody issues and rights that the power of attorney simply didn't provide. So I think the answer to the question is the mother didn't do anything wrong. She did what I think was best for the children. She brought them to a place where they could be cared for. And the grandmother did exactly what she should have done, which was seek a guardianship.
Thank you, counsel.
Thank you.
Justice Clement?
Morning. Can you tell me what the difference is? Why a guardianship doesn't affect a parent's right just as much as a child protective proceeding does? In both cases, they lose the ability to care for their child. So what's the distinction that we should be making here?
Well, the first distinction is in child protection and in juvenile code guardianship, we're talking about potentially terminating the parent's right. There's a long proceeding that precedes the termination of parental rights or the creation of a juvenile code guardianship, which would preserve the parental rights, but would effectively keep the child away from the parent for a long period of time. In a guardianship case, we have two people who both intend to have the child cared for by the third party, by the second person. The idea behind that statutory scheme is that it not last forever. That's the real distinction. When you have child protection and juvenile code guardianship, the idea is for it to last forever. In epic guardianship, the idea is that it be impermanent. And that's the major distinction.
I'm sorry for interrupting. Say that again. In a child protective proceeding, the goal at adjudication is for that to have the child removed permanently?
No, I'm sorry. I may have misspoke if I said that. The goal is to try and get the child, ordinarily, the goal is to try and get the child back in the parent's care. Now, it can be a goal at adjudication to terminate. The prosecutor or DHS can choose to terminate right out of the box or seek to terminate right out of the box. But in general, the goal is to try and get this child back. But the proceeding as a whole can result in the termination, the permanent termination of a parent's parental rights. And that's the major distinction here, because that is not at all the goal in private guardianship. The idea there is to help the parent out, preserve those parental rights, so at some point in the future, they can come back into the picture and care for their children.
I guess that's what I'm struggling with. I'm not understanding that distinction. I'm not seeing how guardianship is different from the adjudication phase in a child protective proceeding. I think the goals are the same, and that is, you know, and not in every child protective proceeding. I understand that there's going to be certain cases that are, you know, that rise to the level of at adjudication that termination is sought. But it seems like the goals in general at those phases, whether it's guardianship or adjudication in a child protective proceeding, are to help the family and you know, the child, the parent, be able to come back together as a family. So I'm just, I guess, and if you have any other thoughts on that, otherwise I'm just, that's what I'm struggling with.
Okay, thank you, Your Honor. I think there are two main distinctions there. One is the permanency side, which I've already touched on. The other one is the government's involvement in the case. I think where you have two private parties, such as in an epic guardianship, a 2B guardianship, that's much different than where you have the executive branch seeking to step in, take custody of a child through adjudication, and potentially terminate rights or put them on some kind of a case plan to consider whether those rights should remain.
Thank you very much.
Thank you, Your Honor.
Mrs. Kavanaugh?
I just want to correct or make sure that I understand the record correctly, because you mentioned that you know, 6 months down the road here. So the children were left with your client in June, and the temporary guardianship was entered in September without notice, correct, to the mother?
Yes, I believe that's right.
Okay, so that's not 6 months, that's 3, correct?
I'm sorry, Your Honor.
And then continued, right? And I guess, you know, you suggest that maybe it's by raising it in the Court of Appeals, challenging the initial award of the guardianship, or the Court of Appeals doing that it's skirting around a collateral bar rule. But this isn't in a separate action, right? It's one continual action.
I think in child protection, yes, it would be one continuous action, but in private 2B guardianship, it would not be one continuous action. It's the same case.
Separate case number?
I'm sorry?
Is there a separate case number? Are we in a
There's
separate
not.
from when the original guardianship was entered?
No, there's not a separate case number, but I think the distinction to be made is there's separate orders. And when there's,
But I mean, in any case, I mean, civil, criminal, there's all sorts of orders that are entered, and there's the general rule that a final order brings up all prior orders in a particular case. I mean, I agree with you. I think that this is sort of a curious or unique animal of, I'm not sure when a final order is ever actually available. So isn't it, but so it's not really collateral bar rule, right? Because we don't have a separate, it's not challenging in a separate action an order entered in a different action. It's really more of a preservation issue, perhaps, right? Or, and if there isn't a requirement earlier that it has to be appealed, a non-final order has to be appealed, why is she precluded from challenging that at any stage in the action?
thank you, Your Honor. I think it is a final order. I think the initial guardianship order is a final order. I think it's a modifiable order, but we have modifiable non-final orders all the time. For example, in a custody proceeding, we have a final determination about where a child is going to live in that custody determination. And that determination is always modifiable into the future until the child turns 18. So I think this is a similar situation.
Because our court rules, the appellate court rules define what a final order is, correct? And there are particular definitions that apply, like you say, to a custody order or such, but I don't, and correct me if I'm wrong, I don't think that there's a particular definition of final order in the appellate rules that applies to this situation. And the general final order rule is the first order in a case that resolves all claims and parties. Clearly, an award of an initial guardianship doesn't meet that definition. I mean, the judge here itself said, hey, wait a minute, this isn't final, this isn't forever, this is just, you know, the whole point of this is that it doesn't actually, you know, it's always reviewable. So it's not final in that respect.
Well, I think there's a distinction to be made between a final order and what the case is going to do in the future. I think you can still have a final order and still have a determination of where the child is going to be in the future. So just like in a custody case, I know there's that distinction in the court rules to be made, but I think in a practical sense, like a custody case, this is a final order, it's fully modifiable, and we're going to completely review this in the future, either at 1 year or when there's a change in circumstance and someone wants to bring a motion for modification or termination of the guardianship order.
Okay, and then just to find out, and I think that this is correct, but confirm for me that at the time that the initial guardianship was entered, she was not, or the first time I guess that she came into court, she didn't have an attorney to advise her of the ability to appeal or the obligation to appeal. And I'm correct that the trial court did not advise her of that as well?
I know she didn't have an attorney. I couldn't say whether the trial court advised her of the right to seek counsel, but I do believe.
The trial court didn't say, look, you need to take this up now or forever be barred from doing that. You know, you can maybe later on down the road challenge whether or not I'm right to deny your motion to terminate. But if you don't sort of challenge this initial point, you know, this is your chance to do it. She didn't have an attorney or the court telling her that that's the case, assuming that is what it should be.
You know, I don't recall if the court did that. Knowing the trial court judge myself, I would expect that at some point in the record, he did advise her. It would be within his character to advise every time. He's very careful with his records, but I don't recall whether he did that on my own.
Okay. All right. Thank you.
Thank you.
Justice Welch.
I don't have any other questions.
I have one short one.
Thank you for holding.
I think we better hold on because that might mean Justice Bernstein got disconnected. Sorry, everyone. Maybe today we'll get to hear the key change that I love. I'll tell you when it comes in. Justice Bernstein, are you connected?
I'm sorry, he disconnected. I'm trying to reconnect right now.
Okay, okay. We'll hold.
Thank you for holding.
Okay, thank you, Larry.
All right,
Yep.
Justice Bernstein, I hear you're back. I'm going to continue. I had a question for you, Mr. Permet. It sounds a little to me like the process you're describing for terminating the guardianship has a best interests type of test, which is one we use in a custody context, and we use it because there are two people with constitutional parental rights in that proceeding, right? They both have the constitutional right to parent their kids, so we use that test in that kind of dispute. Why would that make sense in a dispute between one parent and one non-parent?
Well, I think we're always looking for the best interest of the child, Your Honor.
Well, no, I know, of course, but you see my question about the difference between two parents and a parent and a non-parent, right?
Certainly, and I think there are always going to be different constitutional rights. The parent has a constitutional right to raise their child, and the third party does not.
Okay. All right. Let me go to Justice Zara. I know we've already used so much of your time and everybody else's time. So Justice Zara.
Thank you. I have no questions this time.
Okay. Thank you very much, Mr. Permet. That was, thank you for indulging all of our questions. Professor Sankaran, you may begin.
Thank you, Your Honor.
Please the court. Vivek Sankaran on behalf of Maria Orta. As Justice McCormick, as you just pointed out, guardianship proceedings directly implicate the fundamental rights of parents to raise their children. And that's the lens through which this court must view the two issues before it today. On the first issue about the Ferranti reasoning, the Court of Appeals correctly held that Ferranti's reasoning applies here for three reasons. There were three key points in Ferranti, all of which apply in this proceeding. First, that the order being appealed is a non-final order as part of the same continuous proceeding. So the collateral attack rule that Hatcher talked about wasn't really, did not apply. Second, in Ferranti, just like in here, parents did not receive any notice that they had to appeal the non-final order or that they would forever lose the right to challenge that order. And third, that the order affected serious constitutional rights. All three of those considerations apply equally to an appeal of an initial guardianship order. There's also two additional considerations at play here that were not at issue in Ferranti. One is that at the time of Ferranti, there actually was a court rule that told parents that they had a right to appeal the initial adjudication, the initial dispositional order. There is no court rule, no statute, nothing that indicates what orders in a guardianship case must be appealed. And second, as Justice Kavanaugh pointed out, there's no right to counsel. There's no one to advise a parent of any legal obligation they must take while you still have serious constitutional issues at play. On the second issue, regarding the word reside, the Court of Appeals correctly held that the word reside suggests an intent for a long-term placement. That's the word. That's the way that the word has been defined consistently by this court, by the Court of Appeals. But there's also a constitutional element to this, which is, as Chief Justice McCormick, you just pointed out, once a third party overcomes this initial standing barrier, this initial proof that of the three criteria, that a child reside with them, a child is still living at the time of the guardianship, and the parent left no legal authority for the guardian, essentially the guardianship statute views them as equal players throughout the rest of the proceeding. It's a simple best interest inquiry. And so the way to preserve the constitutionality of this framework is that initially you have to have a narrow front door, a higher standard of proof that must be met by the guardian before you can essentially say that the parent has ceded their constitutional rights to a third party, thereby viewing them at equal playing. I wanted to draw this court's attention to a recent decision at the Court of Appeals, a published decision called In Re Versal. I did file a letter of supplemental authorities with that case. I think the application is pending before this court right now. But the Court of Appeals essentially said the guardianship framework is constitutional because of this high pleading requirement and the high evidentiary burden at the outset, so that once a guardian meets it, then they are on equal footing. But until that happens, then certainly the constitutional presumptions apply. So the Court of Appeals, got it right on both issues. We would ask that the court deny the application for leave to appeal. I'm happy to answer any questions this court might have.
Thank you. I'll start with Justice Viviano.
Well, I guess I haven't looked at that other application yet, but is it your view that the best interest consideration that's in the statute is unconstitutional?
It is not. But my view is that the only way it is constitutional is because of the high proof that must be met before you even get to the best interest standard, which is that a parent has to have an intent to leave a child long-term with a third party. That has to be proven. The parent left the third party with no legal authority.
What happens when the parent has an intent to leave them for a short period of time?
I don't believe the guardianship proceedings are permissible in those situations. That I think that one of the appellants in this case set forth no standard in terms of what the word reside should mean. And it could apply equally to a member of a military leaving his child with his mother. It could apply for me leaving my children on a vacation over the course of a summer. And I think in this case, it was 3 years that before my client was able to get a lawyer and challenge this. And so I think the way that, because, oh, go ahead.
But she doesn't need to get a lawyer to challenge it. I mean, all kinds of people proceed in pro per, and the statute's pretty clear that she could challenge it at any time. She could challenge it the next day, right?
That's fair, Justice Viviano. I think that in terms of the best interest standard, that constitutionally is only permissible once, typically in a child protective case, it's a proof of unfitness. In the child custody presumption, the statute's very clear that the third party has to overcome a parental presumption by clear and convincing evidence before you can get to a best interest sort of equal footing type of consideration. And so that's
curious though. You abandon your child, but you only do it for a month. Then the court shouldn't ask questions when you show up again and you want to reassert your parental rights. They just hand the child over to you. Don't ask any questions about what happened in the last month.
Well, I think, Justice Viviano, the use of the word abandoned would actually suggest it might actually meet the intent for a longer term placement. Our clinic handles cases all the time where it's not a long period of time, but the actions, the trial court makes a determination that the parent has intended for someone else to raise their child. And that's not the facts of this case. When they were in constant communication, she left a power of attorney, she left food, she left clothing. And so the facts of this case don't actually align with any proof of abandonment whatsoever.
All right, thank you, counsel.
Justice Bernstein?
Hey, counsel, good morning. I have a lot of concerns about this, and I'm just going to kind of follow up a little bit with what Justice Viviano was asking, but I'm going to kind of take it in a little bit of a different direction. I think that people now are in crisis. There's a lot of folks that are just totally in crisis. And I guess my concern here is that what do we do? I mean, I think that this isn't going to be an uncommon situation due to desperation. So how do we address the fact that people who are desperate because of the current pandemic and because of the current issues facing it are going to do whatever they can for survival, and that might mean trying to figure out how to allow their children to survive. I mean, this seems to be somewhat of a draconian response, but tell me if I'm wrong.
You're right. I don't believe that involuntary guardianships are what responds to the concerns you're talking about. First of all, nothing in the law prohibits consensual agreements. And so, we want a world where people might be leaning on each other. And in fact, in the guardianship context, there's a form of guardianship called a limited guardianship, where a parent consents for a third party to care for their children. And it's a lot easier, once the parent, addresses whatever concerns, to get their child back in a limited guardianship. There's power of attorney and ways to delegate parental authority for short periods of time as well. And so I think, those are the tools. What we're talking about here, though, is a guardianship being imposed against a parent's consent, taking them away, taking away from them. So I think there are tools in the law to address the concerns that you're raising.
Great. Counsel, thank you very much. You answered my question. Thank you.
Justice Clement?
Thank you. I think when you started, you said that the Court of Appeals applied Franti correctly. So my first question is, do you think that they really relied on Franti? Because the way that I read it was, they said that the petitioner could appeal because the guardianship is a continuous proceeding, and then they added a citation to Franti. So I'm curious as to your thoughts on really what the Court of Appeals did there. And then do you think that you even need Franti in order for this decision?
So on the first issue, I will readily admit that the Court of Appeals did not dig into this issue and analyze their reasoning as much as they should have. There's no doubt about it. It was a kind of a throwaway cite to Ferranti without much analysis. On the second point, Ferranti isn't directly applicable. The reasoning applies, but the general rules of civil appeals is what we rely upon here, which is the general rule of any civil appeal is you don't appeal non-final orders until a final order is set, unless there's a specific statute or court rule that requires that you have to appeal a non-final order. I do want to be responsive. Justice Viviano raised concerns about finality, and it's almost the same conversation we had in Ferranti that I had with Justice Markman, which is this is a court rule fix. There is no court rule right now that suggests when you have to appeal what order in a guardianship case. And after Ferranti, this court took leadership and delineated exactly where and what orders need to be appealed in a child protective case, so we can balance the tensions between constitutional rights and the right for finality. I would advise and recommend that that's what needs to happen in guardianship proceedings, because it doesn't exist right now, but that's the type of clarity. There's nothing in the court rule about what a final order is in a guardianship case. I would argue that under the definition in the civil court and the appellate rules, I don't think maybe the only order in a guardianship case that's a final order would be an order returning a child back to a parent.
To go back out of order here, does the Court of Appeals turn down claims of appeal on initial guardianship orders?
I don't know. I mean, they didn't turn it down well, I don't know, Your Honor. I think the challenge is there's very little published case or unpublished case law in guardianship cases in the entire, in the jurisprudence of the Court of Appeals, because people don't have lawyers and they're very rarely appealed. And so I could not find any jurisprudence or any analysis.
In this case, I know you were concerned about people without lawyers, but your client, she challenged back in December 2016 to terminate the guardianship, but well before she decided to, she waited 2 more years to now appeal the initial decision that was made some years earlier, right? I mean, isn't the concern that the children's lives, they develop, they grow, they mature in one environment over several years, and then we make a dry legal determination that, oh, you didn't meet some technical standard 3 years ago, so just like you're a bag of groceries, we'll just hand you from one person to the other. I mean, the children aren't a commodity, right? I mean, I'm just trying to figure out what are we doing here? The statutory scheme says the parents can come in at any time and try to terminate the guardianship and prove that they're ready to go again. The parent here is the person who initiated all this by her own action, right? I mean, it's not that somebody came and took the children from her, certainly not the government. What is it that we're trying to do here? What are we trying to accomplish? And how does this possibly help these children to make the decision on a consideration other than their own best interest?
Your Honor, with all due respect, I see it a little bit differently. I think the 2 things I see differently is, one, is we're looking for procedural clarity that balances both the rights of parents and the interests of finality for children, and that doesn't exist in the statutes or court rules right now. There's nothing at all.
We can talk about amending the rule, but the question is, how does it make sense to go on a proceeding that's been gone on for years, where the parent already made this argument in front of the trial judge in 2016 to terminate, and then didn't appeal that decision and didn't appeal the earlier decision, and has let this go on for this period of years, now to go back after the system has invested resources, after the guardian has provided an environment for these children for many years, and say, oh, there's some legal technicality 5 years ago, and so we're just going to pluck the children out and put them back with the mother, and we're not going to consider whether that is it and whether that's a good thing to do for the children. We don't care about that. The system doesn't care about that.
I would disagree that the issue that we're talking about is a technicality. I mean, the issue that we're talking about is what needs to be found to take away a fundamental right of a parent to raise their children, because the entire proceeding, the 3 years, were simply comparing homes. It was simply saying, we believe that the guardian has more money, more space. I mean, it was as if they were on equal footing. And again,
let me say this. The system has all kinds of safeguards built into it. The parent can file a petition every week to regain the children, and they can appeal that determination every week. So it's not like they're stuck forever. In fact, they're not stuck at all. I don't, what's the problem that we're trying to solve here?
The lens through which the court was viewing this entire case was wrong, because it got that wrong decision at the beginning, which was it was viewing at every motion to terminate, they were viewing both parties as equal players, not affording any constitutional presumptions whatsoever. And in the guardianship framework, the only place where those constitutional presumptions are applied by statute is at that very first determination. And once you overcome that.
Now you're saying our statutory scheme is unconstitutional.
I'm not. I'm saying that in order to preserve the constitutionality, that word reside has to mean something more than a temporary arrangement. And that's the way that the rest of the scheme affords deference to the rights of parents.
I don't know if Justice Clement was finished with her questions.
I wasn't done. One more thing. Do you think that defects in an adjudication affect the termination in a child protective proceeding, I don't know, more clearly, or that's more obvious as opposed to defects in an initial guardianship determination that affects the motion to terminate the guardianship?
No,
What are your thoughts on the difference between the two?
I think they're identical in terms of that both are interim decisions. The goal is to send a child back home. If anything, the guardianship defects are more pernicious because of the procedural infirmities in the guardianship process, and that they don't have a right to counsel. And this notion that's underlying, the appellant's brief about how these proceedings are more benign than child protective cases. I would really push back on that. In the child protective proceeding, you have a caseworker, the right for reasonable efforts to keep a family together. You have state-funded services. You have a lawyer. The standard is not best interest in a child protective case to reunify. It's a substantial risk of harm of sending the child back home. It's a very different legal standard. And in guardianship proceedings, what happens in the years of guardianship there's a separate ground for termination that is solely based on probate guardianships. And so the same exact danger exists that a child could permanently lose their right to have a relationship with their parent based on what happens.
Thank you.
Justice Kavanaugh?
So I guess I just want to sort of explore a bit the idea or the problems that I think generally may be created, and I think here were by the lack of counsel for the mother, the lack of the right to counsel, right? In a TPR case, they do by statute. A parent is entitled to that. And as we've talked about here, there are very similar considerations and concerns and constitutional implications, right? And I think really, and maybe you can speak to this, and I guess it's building a bit off of the conversation you just had with Justice Viviano about, she challenged the guardianship in December. And then it wasn't like she just did nothing for 2 years, right? She was sort of faced with the situation, again, unrepresented, with perhaps maybe an attorney would have told her that it might have been better to challenge it then, or, whether required or not. But instead, she was faced with a choice of actually trying to do what the trial court was saying she needed to do in order to, actually get this guardianship terminated, right? Stay and work at a job, find housing, actually do these things to try and get her children back for 2 years or so. So it's not, I guess I could be understand in a case or be less sympathetic to somebody who challenged it and then did nothing for 2 years and then, came back later. That's not the fact in this case. But I think, do you think that the lack of counsel factors into that of a parent who is sort of, stuck with she's trying to do what she thinks is best to get her child back, and that may not be consistent with what we as lawyers and judges think that she should do as far as appealing an order?
Justice Kavanaugh, I think it absolutely does. In so many different respects, the lack of counsel affects parents in guardianship cases. First, just on this very issue that we've been circling around as to why she didn't appeal what order at what time, I really want to make it clear to the court that there's nothing in the law, the court rules, the statutes, in case law, that explicitly says in any way that she can appeal the order that we're in a way, blaming her for not appealing sooner, nor to the trial court at any hearing in this entire case say you can appeal this order. That never happened in the record at one point. And so practically, if she had a lawyer, maybe a lawyer could have suggested that she do this, but to hold litigants accountable about not being able to challenge a fundamental right when nobody, no lawyer, no judge, no statute, no court rule says you can do something, would be a serious constitutional issue. But second, practically, the guardianship proceedings have such fewer procedural protections than child protective cases in terms of the other supports that a parent has, that when we have in our clinic represented parents in guardianship proceedings, it is of invaluable assistance to them because they need the help to figure out how to balance the competing tensions that you're talking about, which is, do I challenge this? Do I go along? What do I need to show to the court? There's no caseworker. What do I need to show to the judge to undo this? Because inherently, the way the statute is set up after that initial determination is that it's pleasing the judge. It's purely a subjective best interest determination of what this particular judge needs to see. And that's, I think, the reason why counsel is so important in this system.
Thank you.
Justice Welch.
Yes, thank you. I was just wondering, one of the questions or one of the points that was made is that if we go along with this sort of new permanency requirement, that it could lead to a flood of more child protective proceedings. And I'm just wondering if you had what your thoughts were on that.
So I have two thoughts. One is, I don't believe it will. I think that families have informal arrangements all the time to care for children. And this case represents one of them. There wasn't evidence. Child protective systems don't open cases unless there's findings of abuse or neglect. It's a pretty significant standard that must be met. And the case law is clear that a family's poverty or housing instability isn't enough to trigger a child protective investigation. Secondly, I think there's an argument as well that parents like Ms. Orta would have been better off in the child protective system when there's much more procedural clarity. It was 3 years of losing her children before she got a lawyer and was able to appeal this. And so I'm also not necessarily persuaded that that would be a bad thing for parents who are stuck in guardianship proceedings for lengthy periods of time, that many of them might benefit from getting a lawyer and having a caseworker and state-funded services to help, and a clear delineation, a case plan, right, which outlines exactly what you need to do to get your child back. That's a step above this ambiguity that exists right now in this case and in many guardianship cases.
Great, thank you.
Justice Zara.
Thank you. I just briefly want to make sure I understand your position with respect to your initial exchange with Justice Clement. There's been a lot of discussion of Ferrante, and I think you indicated that the Court of Appeals could have done a better job of explaining its reasoning. I guess my question is repetitive of what Justice Clement said, but I want to make sure I understand your position. It seems to me it's undisputed that the collateral bar rule only applies to two separate proceedings, and Ferrante held that a termination proceeding is a single proceeding, rendering the collateral bar rule inapplicable in that context. And it seems to me here the guardianship proceeding is a single continuous proceeding. So I don't really see where Ferrante comes into play, or why is this an extension of Ferrante? Is that what you're advocating for? Do you need it?
We do not need Ferrante. I think Ferrante showed the reasoning, like as to an adjudication order, as to why the general collateral attack rule didn't apply in that case. And so I use Ferrante as almost an illustrative example of just another type of order where it was in a continuous proceeding, but it's the same. We don't need Ferrante. We're not asking the court to extend it. We're asking the court to apply the same final order, non-final order rule and the same collateral attack rule that has always existed.
Thank you.
Yeah, counsel, I'll just follow up on that. And I know we've already used up way too much time, but I view Ferrante and the Court of Appeals opinion almost as an example of, when the collateral bar rule doesn't apply. But the Court of Appeals could have done the same work it did without citing Ferrante, right? At least that's how I read it.
Absolutely.
Okay. Thank you both. We've used up way more than your time. We appreciate it. The case will be submitted.
Thank you, Your Honor.